Is it trademark infringement if I name my course How to Use Famous Brand? That's what I'm going to spend the next 4 minutes talking about. I'm Angela Langlotz, trademark and copyright attorney, and I go live here on weekdays. If you have trademark and copyright law questions, I answer them live here. Drop them into the comments, smash the like button, and follow me on Facebook or on YouTube because you will get an answer to your trademark or copyright question. So somebody tagged me, as they frequently do, in a question on Facebook. And the discussion was, what if I mention that my course or my product is how to use a famous brand? Well, there is such thing in trademark law as a doctrine of fair use. It's called nominative trademark use. And what that does is it allows you to mention somebody else's famous trademark, famous or not famous trademark, but this usually comes in with famous trademarks, in the description of your goods and services, okay? So it allows you to mention, for example, that your product is about how to use LinkedIn or how to get more clients on Twitter. We see this, for example, all the time in software. The software might say that this is compatible with Apple products, all right? And that's a very important thing for the buyer, the consumer of your product to know. They need to know what operating system your product works with, right? Or your service. So if you say that it's compatible with Apple, you're not saying that Apple endorses your product. You're not saying that Apple is sponsoring your product. You're not saying that your product is associated with Apple. You're just saying that, hey, my software works with Apple computers. And that's important because we have two major platforms that software runs on. We have, DOS, and then we have Apple. So if your product doesn't work on Apple and I have an Apple computer, these are things I need to know as a consumer so that I don't buy the wrong thing. So this nominative trademark use is actually very useful from a consumer standpoint. And remember that trademark law is very consumer focused. We are focusing on the consumer being able to choose the right product or service for them, right? So the same goes for people that teach how to use a certain famous platform like Facebook or Twitter or LinkedIn. They should have the right, and they do under the law, to say that my product is for how to get more clients on LinkedIn or how to get more leads using LinkedIn. But here's the bad news. These big companies often don't respect that doctrine of fair use. So what they will do is they will send you a cease and desist letter if you get too big. They'll say, we don't like that you're using our brand to sell your products. This is true even if you have the disclaimer at the bottom of your sales page that says, hey, our product isn't associated with LinkedIn, or it isn't associated with YouTube, or it isn't associated with Google, or it isn't associated with Facebook. These big companies will try to bully people, and they have endless money to do so. They will try to bully people. So what do? Well, you can handle this one of two ways. It depends on what your appetite for risk is. You can say, well, I'm going to use the nominative trademark as fair use allows me to do. And if I get a nasty gram, I can then either choose to fight it in court, which is very expensive, or I can just stop. So that's one option. Or you can say, you know what? I don't even want a court disaster. I'm just not going to use that famous trademark because I just don't want the hassle. I don't want to get the nasty gram from, Facebook headquarters that tells me to stop. Now, you could stop and pivot and call your course something else. That's an option too. It's all about what you want, right? It's just a business decision. I say this so often to my clients that deciding on a particular strategy is really a business decision. How much money do you want to spend on it? How much mental energy do you want to expend fighting it, et cetera, et cetera. Okay, but there's the law, and then there's the practical application with these big companies that like to bully small creators. The bottom line is this: if you're going to use somebody else's famous trademark in your promotion of your goods and services, be prepared to either get a nasty gram or give it up. All right, so that's the bottom line. If you don't have money to fight with these people, you could give it up, or you could just avoid the situation altogether by using other words to allude to what you're talking about. In the discussion that was being had, we were talking about, big G. And if you say big G in the context of the internet, everyone knows you're talking about Google. So those are the ways that you can handle that. I'm Angela Langlotz, trademark and copyright attorney. Find me online at TrademarkDoctor.net. You can also find me on Facebook, facebook.com/TrademarkDoctor. And I have a huge channel on YouTube that's updated every weekday. Just go to YouTube and search Trademark Doctor.